Hello, welcome everybody. Good morning, good afternoon or good evening, depending where you are in the world. We're delighted that so many of you have tuned in to receive this Bristow's patent case law review for the year 2020, and you are all very warmly welcome. My name is Dominic Adair. I'm a partner at Bristow's, and I'm joined today by my colleagues Katie Cambrook and Naomi Hazenberg, who are senior associates at the firm. The agenda for this webinar is on the next slide. Let me show you that. We're going to begin with a few minutes from me looking at the court system and the statistics from 2020. Then I'm going to hand over to Katie and Naomi, who will take us through the countdown of the year's top cases. The selection of cases, as ever with this Bristow's review, is a personal one, but we've tried to capture the cases that we have found most interesting. But before we begin, just a few words of housekeeping from me. We're going to try and aim to finish this seminar in 1 hour, but there is a risk that we might run a few minutes over. If that happens and you need to leave, or if you need to leave at any stage beforehand, please do try and catch up with what you've missed later, because we are recording today's session and we intend to make the video recording available afterwards, so you won't miss out. But assuming we might have a little bit of time at the end of the webinar for questions, do please use the question box on the GoToWebinar platform to type in any questions you would like us to answer. I'll keep an eye on that as the presentation proceeds. And finally, this presentation always coincides with the release of our written review of patent cases. Many of you will have received that publication in hard copy over the years previously. This year, because we're still in a slightly strange time, the office isn't fully staffed at Bristow's, we're not able to produce a hard copy. I'm sorry, but we are going to produce a soft copy, and we'll be able to send that out to you by email next week as a PDF. If you don't receive that next week and you would like a copy, do please drop me an email and I will send it to you personally with great pleasure. So with that said, it's time to start the show. I'm going to take the first few slides and start with a look at the court structure as it stood in 2020. So the faces on the slide are all judges that hear patents cases. We haven't shown them all. We've tried to focus on the sort of patent specialists. But one point to make early on is there's a box down in the bottom right called deputies. There was a large number of deputies hearing patents cases in the High Court in 2020. And that's partly because the Patents Court itself was a little bit underpowered. Lord Justice Arnold had gone up to the Court of Appeal in 2019. So Mr. Justice Burse was really having to work quite hard to get through the cases and relied a lot on the assistance of deputies. In October in 2020, it was announced that Mr. Justice Burse would be going up to the Court of Appeal. That didn't happen immediately. It happened only in February this year. So that left a vacancy in the Patents Court as of February this year, which was filled by Mr. Justice Mellor. But before that, in September 2020, we had Mr. Justice Mead joining the Patents Court and starting to help out on those patent cases and already delivering some interesting judgments. Lord Justice Floyd will retire. He has retired in February this year, and that really completes the picture of change. Looking at the top of the scheme in the Supreme Court, we've shown 6 of the 12 Supreme Court judges there. Only 5 of the 6 heard the 2 Supreme Court cases that we'll mention in our review today. Lord Kitchen wasn't able to hear either of them because he'd heard them before when he was sitting as a judge in the courts below. So it's the other Supreme Court judges that heard those cases. We couldn't leave Lord Kitchen out, however, because he is probably the best Supreme Court patent judge of all. So let's have a look at some numbers. It was the year of the pandemic, and still is, of course. So that did have an impact. There were 66 patents decisions handed down across the various courts, and that's a bit of a drop from the number 86 in previous years. That number you probably think is quite a high number, but that's because it covers everything. It covers costs decisions, interim application decisions, and full trial decisions. So that's why the number is quite high. If we look at the number of full trial decisions at first instance, the number is actually higher than the year before. So we had 16 judgments from the Patents Court in 2020 and 3 in the IPEC. If we look at the number of appeals, we had 10 in total. 2 of those from the Supreme Court. 3 were actually appeals that were heard in the High Court, because they were appeals from the UK Intellectual Property Office, and 5 of the 10 were heard by the Court of Appeal. In terms of the subject matter of the cases, we always say that life sciences and telecoms dominate the court's list. I think that will always be true. It was certainly true again in 2020. But let's have a look graphically at what those numbers look like. You can see at the far right of this trend bar chart that 2020 was characterized by the patents court, the big light blue chunk in the middle of that column, being busier than probably it has been in about 5 years, churning out those first instance decisions. And you can see what I mentioned there with the Court of Appeal in yellow, just doing a little bit less than it has in previous years. What's remarkable about the output of the patents court in this situation is, I mentioned earlier that we didn't have that many patents court judges, and this next slide really shows the extraordinary achievement of Colin Burst, that line at the bottom there, working so hard in the patents court to churn out the judgments, about 22 or 23 judgments from Mr. Justice Burst in 2020, and far exceeding by more than double the output of any other judge. You know, if this was an athletics competition, Colin would have run a lap of the track in the time it had taken some others to do just 100 meters. He really was an extraordinary achievement. In silver medal position, if we can put it like that, is Mr. Justice Marcus Smith, hearing about 7 or 8 cases. Not a name hugely familiar to patent practitioners before 2020, but came to prominence with his decisions in the Neurim case, which Katie will talk about. And behind Marcus Smith, we've got Douglas Campbell, working hard both in the Patents Court as a deputy, in the IPEC, and still maintaining a practice at the bar. Okay, so let's look at outcomes next. How did we get on in terms of the results of those cases? Validity hit about 50% in 2020. So that is about half the patents that were before the court were held valid, up a little bit from the previous year, but probably not significant when we bear in mind the sample size is relatively small. I think we can say that that's probably within the noise of the analysis. But if anything, you know, a good news for patentees that validity has gone up. But infringement, though, has come down a little bit. Again, probably not significantly so, and resting there at about 60% of patents being found to be infringed. The point that I would note more generally on the infringement trend is how it's dropped over the last 3 years, since 2017. When we had the doctrine of equivalence introduced by the Actavis and Lilly case in the Supreme Court. I remember saying at the time in 2017, giving this presentation, do we really need a doctrine of equivalence when the infringement rate is about 90% as it was in that year? Do we need to make infringement more likely by using the doctrine of equivalence? Well, pleased to say that hasn't happened. Despite having the doctrine of equivalence, the number of findings of infringement has dropped off a little bit from that probably anomalously high number in 2017. So if we look at what that actually looks like in terms of doctrine of equivalence statistics, this is a table that records, I think, every doctrine of equivalence case that we've had so far since that July 2017 decision in Actavis and Lilly, where we got the doctrine from the Supreme Court. You look at the bottom of the table, you'll see 6 rows that record the doctrine of equivalence decisions of 2020, and we've got 4 findings of infringement under the doctrine and 2 with no infringement. They're the red rows are no infringement. Overall, you can see that the table is dominated by the blues, so overwhelmingly the doctrine of equivalence is delivering infringement more often than it's not. But at least in 2020, the picture was a little bit more balanced, because before that it really did look like it was a prize every time for patentees asserting equivalence. In terms of outcomes otherwise, this pie chart shows the number of patents that were held valid and infringed, or valid and not infringed, etc., as the case may be. So it's an outcomes per patent statistic, and you can see that the dominant return result was valid and infringed by more than 50%. So again, you know, not a bad year for patentees. Often the statistics have gone the other way. So finally from me on this slide, a look at the different grounds that had been asserted against patents challenged in 2020. We're looking here at the granularity of the pleaded attacks against the patents. So the way this slide works is that in the background of the patent, in the background of the slide, you've got the number of pleaded counts. So if we look at obviousness, that middle column, we've got 19 times obviousness was pleaded against patents, and the column in the foreground is the success rate of that challenge. So 13 out of 19 attacks based on obviousness were successful. That's a kill rate of almost 70% for inventive step, which is pretty high. Previous year it was 44%, I think, kill rate for obviousness. The only other one I would probably draw attention to is added matter on the right-hand side. We've got 4 attacks of added matter pleaded, succeeding 3 times out of 4, 75%, which is quite a high figure for added matter in the UK. We normally like to say in this presentation that the UK judges are quite generous to patentees on added matter, unlike the tribunals of the EPO, which are a bit tougher. But it does seem that, at least based on these statistics, 2020 was a year where the English courts did get a little bit tougher on added matter in patents. So conscious of the time, I'm going to hand over now to Katie and Naomi to talk us through our top 10 case countdown.
Thanks, Dom. And I'm up first in number 10 slot with the first case, which is Empson and Hozlo and the appeal thereof. So what was the background facts to this case? Listeners may recall that the Hozlo case featured at number 7 in our top 10 last year, following the first instance decision from Mr. Justice Nuji. And that was for 2 reasons. Firstly, some novel and interesting obiter comments from the judge on what amounted to a public prior use. In this case, the inventor had made some prototypes of the product in his sunny Florida garden, and the judge had made a finding that that wouldn't be a public prior made a comment that that wouldn't be a public prior disclosure. Secondly, it made the top 10 last year because the decision came that the patent was held obvious over the piece of prior art you can see on the screen there, the Mcdonald patent application, which came from the field of aviation. The patent and that particular piece of prior art had been before Mr. Justice Burse and the Court of Appeal on a previous occasion, and the patent had been upheld. And that really, the difference in the decisions came down to kind of the scope of the skilled team. And Empson, therefore, were unsuccessful at first instance before Mr. Justice Nuji, and appealed that decision on the basis that the judge had erred in principle as he conducted a hindsight analysis and had not taken commercial success into account. The respondents, Hozlo, challenged the findings of infringement, entitlement to priority, and the prior use findings. So what happened on appeal? Essentially, the decision of Mr. Justice Nuji was upheld. Lord Justice Arnold gave the leading judgment with which Lord Justice Henderson agreed. Although, interestingly, and something we'll touch upon in a moment, Lord Justice Floyd gave a strongly dissenting judgment. Arnold's first comment of the appeal was that the appeal seemed unpromising, as the judge had made several statements throughout his judgment that he was avoiding hindsight. So not really the best start for Empson. The appeal decision is lengthy, and Arnold steps through each of the judge's findings, finding on each occasion that no error had been made. A particular point just to mention from the appeal decision were findings that given the skilled team was a designer of hoses in general, they wouldn't simply dismiss the Mcdonald piece of prior art, even though it comes from a different field, and the experts said that they wouldn't have read it. And even though the field of hoses itself was quite limited in terms of development, that was not held to be something that would be prejudicial and prevent the skilled person from seizing upon the idea in Mcdonald itself. On commercial success, the Court of Appeal confirmed that this can be of assistance where it provides insight into the thinking of the skilled person when considering a particular piece of prior art. However, this ground of appeal was no assistance in this case because there was no evidence that anyone in the hose industry knew about Mcdonald. In fact, quite the opposite was true based on the evidence. I think it's fair to say that both Arnold and Henderson expressed some sympathy with the inventor for the decision and noted that it may seem harsh, but the principle that even the obscurest piece of prior art can invalidate the cleverest of patents is one that is known. Lord Justice Floyd strongly disagreed, and he considered that Mcdonald was a mere paper proposal. He obviously acknowledged that this principle to invalidate a patent which the skilled person, on the basis of a document the skilled person would never see, it is a valid one, it's there for policy reasons, but that those policy reasons lose weight in a case like this one, where the evidence is the skilled person wouldn't even look for the document. He also acknowledged that the law has found ways of mitigating the harsh rule. And Lord Justice Floyd felt that the judge had been misled into treating the mere paper proposal of Mcdonald as an actual thing which had been made, when both experts had said that they did not understand how it fully worked. As such, Lord Justice Floyd felt that the judge had made a number of errors of principle and he would have allowed the appeal. So why is this case important? If we needed it, it confirms that even the obscurest of prior art can invalidate a patent. It demonstrates the importance of expert evidence and really thinking who is in the skilled addressee of the patent and who's in the skilled team. It also shows that highly experienced patent judges can have strongly held opposing views on a particular point. And finally, it arguably leaves open for another day any argument on those obiter comments on prior use in the inventor's garden. There was some comment from Lord Justice Floyd towards the end of the decision that he wouldn't disturb the judge's findings on the respondent's notice, which included this issue of prior use, but it wasn't dealt with in any detail in the judgment. So one to watch out for.
Great, thank you, Katie. So over to Naomi now. It looks a little bit like on my screen she may have frozen.
It does.
Are you there, Naomi? No, I don't think she is. So I wonder, Katie, if we might skip on to your next case, and I'll message Naomi and see if she can reboot her her connection. Would that be okay?
Yeah, that's absolutely fine. You keep the life sciences theme going.
Yeah.
So on to number 8. And we're looking here at the case of Alvin, Abbott versus Edward Life Sciences. Moving on, just to look at the background, if we can, Dom. In this case, Alvin and Abbott held 2 patents which related to the treatment of mitral valve regurgitation and had their own successful product, the MitraClip, which was available on the market. Edwards had developed a rival product, the Pascal device, which was alleged to infringe the patents. As is commonplace, Edwards considered that Evalve Abbott's patents were invalid. So far, so usual for a patent action, we might think. However, Edwards had argued that even if the patents were held valid and infringed, they should not be the subject of an injunction, and this was on the basis of arguments relating to public interest. Edwards considered that there is a body of doctors in whose reasonable clinical opinion the Pascal device would be a better device for patients than the MitraClip, and they argued therefore that it was not in the public interest to prevent doctors from doing this, and so an injunction should not be granted. Given the 2 distinct issues, there was 2 trials, one on validity and infringement, and a second a short time later on the public interest arguments. Judgment on the validity and infringement was not known before the public interest trial took place, and ultimately Mr. Justice Burse, who heard both of the cases, handed down judgments in from both trials on the same day in March last year. So looking at the outcome of this case, The patents were held valid and infringed in that trial. The arguments of obviousness over Edwards' own previous patent publications that took place as part of the development work of the MitraClip were not held to render the patents obvious, nor was there any added matter. The claims were held to be infringed either on a normal construction or where this failed under the doctrine of equivalence. And the judgment goes through a very detailed look at the kind of technical background and the way the devices work to come to the decisions that the judge did. On the public interest trial, the judge held that an injunction should be granted. And in doing so, he reviewed the law and the issues on whether an injunction should be granted or an award of damages given in lieu. As a result, he laid down 7 principles from the law, which he then went on to apply to the facts of the case. The principles set out that an injunction is a normal remedy when infringement is found, and it's for the defendant seeking to resist the grant of that injunction to prove why it shouldn't be granted. Public interest is a factor that could be considered when considering whether or not to grant an injunction, and it may well be a factor that justifies damages in lieu of an injunction, and this could be the case where the damages were small or large. However, the judge issued a kind of note of caution saying that consideration must be given to the fact that there were already checks and balances in the patent system itself, laid out in the legislature, and those helped already to balance this difference between what's protecting the monopoly and protecting, the rights of others in the marketplace. Parliament, as I said, had set that balance, and it was not for the court to undo this. So while the court had jurisdiction to do it, it should do so sparingly. The judge considered that for the public interest arguments of the type being run by Edwards to begin to be relevant, they must be concerned with a serious medical condition and possibly only life-saving medicines. It was held not enough that allowing doctors to exercise their clinical judgment in the best interests of patients couldn't prevent the grant of an injunction. Not all opinions were held equal, and for the court to make an assessment of such opinions, objective clinical evidence was required, which wasn't available in this case. The relevant public interest sufficient to justify the refusal of an injunction is where a need to protect the lives of patients for whom the infringing product is the only suitable treatment, and it would be necessary to have a clinical evidence to prove this point. So, why was the case important? It kind of sets again for us those boundaries of where and where the balance will be between when an injunction may be granted and when it won't be. It resets or reconfirms the level as normal. It will be normal to have an injunction, and it's important for patentees and opponents to consider when looking to carve out or seek to prevent an injunction from being granted, what evidence they need to engage the principles and considerations laid out by Burse in this decision and the types of cases it will apply to. It seems to have, as a result of this decision, limited them only to the prevention of a grant of an injunction to only those cases for life-threatening medicines where the objective evidence suggests there is no other treatment.
Great, thank you, Katie. I think we do have Naomi back with us, but I think she's turned the camera off to try and improve her signal. Great, yeah. Thanks, Naomi. So, do you want to circle back and pick up your earlier case, or do you want to just take it up from here? It's up to you.
I'm happy to go back if that works for you all.
Very good.
Right, so this was a decision of Mr. Justice Burse where he was looking at an appeal on behalf of a decision from the comptroller, and Lenovo's patent was entitled Selecting a Payment Card, and it was refused on the basis that it related to a computer program and business method as such. The invention related to dealing with the card clash problem where more than one card was presented and each related to a separate payment account. The method of the patent split that payment automatically between the accounts on the basis of a preset percentage by the user. So what happened when the judge looked at it? Although the judgment is relatively short, there wasn't also much of a dispute about the applicable law, but it does contain an interesting discussion on the approach to the Airtel steps and a detailed consideration of the first and the fifth AT&T signpost. So just looking at the first signpost to start with, and that's whether there's a technical effect on the process carried on outside the computer. Lenovo argued that there were two physical interactions. Firstly, not having to present multiple cards, one after the other, and secondly, not having to manually and actively select the payment split. The judge agreed with the examiner that making a physical interaction obsolete could be sufficient to create a technical effect. However, the first of those supposed interactions was disregarded because it was already known and therefore not part of the technical effect of the invention. When looking at the second interaction, the examiner had found there was no technical effect outside the computer because implementing a button press to select user preferences was well known. The judge, however, said he'd got that the wrong way round. The alleged technical effect came from getting rid of a button press and not implementing it. It didn't follow, said the judge, that because adding a button press was trivial, taking it away was equally trivial. When the examiner had stood back and looked at the invention of a whole, he'd said that the contribution lay in a process that was implemented via a conventional computer, taking financial data and user preferences and deciding the best split. That might happen faster and more efficiently, but he couldn't find any technical effect that lay outside excluded subject matter. The judge, however, said that the key question was to ask, is there a different physical interaction with the world outside the computer compared with what went before? If the technical effect actually lay in the pressing of a button, the answer to this question would have been no. However, as the payment split was being handled automatically, and as a result of that automatic feature, the card clash problem was solved without having the extra physical step of using two separate cards. He said that effect was neither a computer program as such, nor a method of doing business as such, nor a combination of the two. So that was technical in character and enough to get it over the excluded subject matters. So why did we think this was important? As well as several interesting practice points about the approach of the examiner, it's relatively rare to have a case considering the application of the Airtel questions and the AT&T signposts in this level of detail. It's also a reminder that even the most simple of technical effects, here just automating and removing a button press, is enough to get you over the section 1 sub 2 excluded matter tests. Shall we flick on to number 7, and I can hopefully get us back into the right order.
Great.
Right. So this is another case with the Patent Court dealing with an appeal from an IPO decision. And this time it fell to Mr. Justice Marcus Smith, who, as Dom said, put in a bit of a shift in the Patents Court this year. And this was an appeal in which Dr. Stephen Teller had applied for 2 patents, and he'd stated that he wasn't the inventor of the inventions in the application. In the statements of inventorship, he'd stated that the inventor was in fact an AI machine called Dabus, and that he had acquired the rights to the grant of the patent by owning Dabus. He explained that Dabus was a type of creativity machine that analyzed information, generated novel ideas, and ripened them. He stated that it was the machine, not any person, that had identified the novelty and salience of these inventions, and he argued that the output of autonomously inventive machines should be patentable if the patentability requirements were met, but he couldn't claim inventorship himself, as that would be fundamentally wrong and would weaken the moral justifications for rewarding innovation. Dr. Teller acknowledged that the machine couldn't have a legal personality or any independent rights, but he said that as the machine's owner, he should be the default owner of any IP it produced. The IPO rejected those contentions, found that Dabus couldn't be regarded as an inventor as it wasn't a natural person. And as the consequence of those findings was that the right to apply couldn't have been transferred to Dr. Teller, and as he wasn't entitled to the grant of the patent, the application should have been taken to be withdrawn. So when the judge looked at this, he focused on the analysis of Section 7 of the Patents Act. And he looked at Section 7 sub 2 and who was entitled to the grant of the patent. The section set out that it's primarily the inventor, which Section 7 sub 3 defines as the actual deviser of the invention, but it could also be any person who was entitled to apply by an enactment of law or an agreement before the invention was made, or the inventor's successor in title, but it could be no other person. And the judge found that the 3 words at the end of that section, no other person, established that it was only those three classes of people to whom a patent could be granted. Dr. Teller was contending that the definition of inventor wasn't limited to being a person. So the judge turned first to the question of whether the member of these three classes had to be persons. He concluded, without considering the term inventor, that a patent could only be granted to a person, primarily because only a person can hold property. He also concluded that the language of the Patents Act makes it clear that a holder of a patent must be a person. Dr. Teller, as I said before, didn't contend that he was the inventor, but the judge did find it necessary to determine the meaning of the term inventor. And he said that every invention had to have an inventor within that fell within the Class A of Section 7.2, and that stretching the definition in the way proposed was both curious and indefensible. He said that the term deviser implies that somebody had actually devised something. And when he looked at the case of the House of Lords case of Yedder, he found very high authority that an inventor was a person, and he specifically noted Lord Hoffman's comments that the inventor was a natural person. When considering this further, he found it inevitable, in fact, that the inventor had to be a natural person, as invention had to involve an inventive step that wasn't obvious to the skilled person. He also reasoned that those applying in the other two classes could only do so because the inventor was capable of holding and transferring property. As a result of this analysis, Dabus couldn't be the inventor within the meaning of the Patent Act. The judge noted that unlike inventor, the other two classes weren't limited to being natural persons. However, Dr. Teller still didn't fall within any of these two categories because Dabus wasn't a person and therefore lacked the ability to properly transfer property and the right to apply to Dr. Teller. The judge rejected the submission that Dr. Teller had the right to apply because he owned the machine and therefore the output of the machine. In the context of patents, the judge said, for a right to be granted, it had to be applied for, and that had to be done by a person. Without an application by the inventor or a person to whom that right to apply had been transferred, there could be no patent. Dr. Teller expressly declined to argue that he was the inventor, but the judge noted that this way of arguing the case would have been far easier and that he wouldn't have regarded it as improper. So why is that important? It's a case touching on the ever-evolving area of AI inventions, which of course has been the subject of the consultation by the UK IPO with the responses published last week. Those responses generally noted that this was an issue that needed to be addressed. And it's also so it gives us some clarification on what currently means to be an inventor and who can apply, but it does also suggest a possible way forward for future applicants.
Great, thank you.
Thanks, Naomi. And so at number 6, we have a trio, or really just a duo, we're going to address today, of cases involving Neurim and Mylan. The first two cases listed we'll look at, and they relate to a PI application. And the last case on there is a main action, which was also decided towards the end of last year, and we reference it there in case anybody wants to go and take a look at it, but we won't be touching upon that one today. So looking at the background, the facts were that Neurim held a patent for the use of melatonin for improving the restorative value of sleep in patients characterized by non-restorative sleep. Neurim had their own product, Circadian, which was on the market and was one of Neurim's best-selling medicines worldwide. Mylan had obtained a marketing authorization in December 2019 and were saying that they would like to launch as soon as they could. A main infringement action was brought against Mylan by Neurim in February 2020, with a PI application following not long behind that in March 2020. The PI hearing was not held until the 20th of May, with judgment given on the 3rd of June, and just a few weeks later, on the 18th of June, an appeal of that decision was heard. It's an important consideration as we go forward and look at some of the findings to point out that between the filing of the PI application and its hearing in May, an expedited trial had been fixed, and that was to be heard at the end of October. So what happened? At first instance, Mr. Justice Marcus Smith dismissed the PI request. The judge applied the well-known American cyanamide test, which asks first, is there a serious issue to be tried? Then considers the adequacy of damages to the parties before looking at the balance of convenience. Despite Mylan's attempts to argue otherwise, the judge did hold that there was a serious issue to be tried. However, the PI application fell at stage 2 of the test, with the judge holding that Neurim could be adequately compensated in damages. This was despite references to the possibility of other entrants to the market and arguments about consequential loss, including defunding of medical education programs. Neurim appealed this decision to the Court of Appeal, and as I mentioned, the hearing was just over 2 weeks later. The Court of Appeal upheld the decision of Mr. Justice Marcus Smith, but in doing so made it clear that they were not making a new principle of general application to all PIs. It was more specific to the facts of this case, which meant that damages would be an adequate remedy. Of particular importance were matters such as the short period of time, just 4 months, between the grant of any injunction and a trial, the lack of evidence, as the Court of Appeal found it, of another generic entering the market in this time, as well as evidence that 53% of Neurim's prescriptions were by brand, and so even if a generic competitor entered the market, Neurim would still achieve those sales, and that offered it some comfort or protection. All of this, coupled with detailed sales projections for the periods of possible loss, meant that the court considered in this instance no PI should be granted. So why is it important? Do we need to ask the question? I think it's fair to reflect that the first instance decision was somewhat unexpected and made practitioners consider practice and evidence for seeking PIs. For the future, I think it means more consideration than ever will be given to the preparation of that evidence, and that the timing of any application and hearing of that application will be important. As I mentioned, these two factors came up several times in the Court of Appeal judgment, where reference was made in particular that evidence had been prepared before the expedited trial date had been set, and that in light of that date, some of the consequential loss arguments made by Neurim just didn't ring true, as the impacts wouldn't be made out in such a short period of time. The case may be confined to the specific facts, but only time will tell. And I think it's an interesting point to note that Neurim did appeal the Court of Appeal's decision to the Supreme Court. The Supreme Court refused permission, indicating that it was the closeness to the trial date that was the reason for this. However, the Supreme Court appeared to have left the door open to considering the issue in an appropriate case in the future, noting that there was a point of law of public interest, of public importance on whether American cyanamide should be applied in a rigid and structured way, or whether a more overarching and flexible approach to the issues should be taken. So this seems one ripe for future litigation.
Okay, so my next case is the probably now notorious patent family that IPCON owns, which is a patent that covers a scheme for controlling access to a particular telecommunications channel. In this case, it had been asserted against Vodafone's LTE network, and essentially it was a primary lottery bypass system to give direct or priority access to certain users with a secondary lottery access for everybody else. There also exists the Mobile Telecommunications Privileged Access Scheme, which is known as MTPAS, that's been set up by the Cabinet Office, and that's to request from the networks that they give priority access to emergency responders during certain situations. In their defense, Vodafone said that each use of the relevant LTE access method was under this MTPAS scheme and was therefore covered by the Crown Use Defence. They also said that the regular testing they undertook to make sure they could comply with the request if it received was also covered by the defence. At the trial, the judge noticed that this raised a point of public interest, and the controller was invited to intervene, and he did so. Just quickly before I tell us exactly what happened, here's on the next slide is what the MTPAS request actually said that would have been received. Maybe it's just important to point out what it doesn't say. It doesn't say use the scheme of any specific patent. It doesn't say use the method specified in any standard. and it doesn't actually specify exactly how it has to be done. It simply asks the network to give emergency responders a much higher likelihood of being able to make calls than normal customers. So one key fact that made this issue really important in this case was prior to trial, Vodafone reworked their network and stopped using the LTE access control method completely. And they said that in an emergency, they would switch off 4G and use an alternative way to provide this priority access. So on the next slide, we can see that the issue that the judge had to determine was what level of specificity was needed in a written authorization to establish a Crown use defence. The judge broke it down into 4 possible scenarios. First, an express authorization to work a specific patent. Second, an authorization that didn't need to identify a specific patent, but would be impossible to fulfill without infringing a specific patent. Thirdly, an authorization which was similar to that second scenario, but where it wasn't shown that it was necessary to infringe the specific patent to fulfill the request. Or fourthly, just something different. Vodafone argued for the third option and said that any identification of specific patents would place a very heavy burden on the Crown and also almost impossible to fulfill in an emergency situation. The controller and IPCOM argued that even if you didn't have to specify the specific patent, you needed to have necessary infringement. And in looking at that, they looked at Article 31 of TRIPS, which deals with compulsory licensing and government use. The judge, however, went for the third scenario and said that all that was needed is the authorization just identifies the relevant act. He said that was the most natural reading of Section 55 and the most easy way to operate the defence. He said that if you went with something that went with an authorization that was necessary to infringe a patent, you'd open up a raft of secondary questions. And ultimately, he said it was a question of policy, and so he was allowed to decide. So we found this was important because it applied a very broad interpretation on the authorization that's needed for the Crown use defence, and it arguably could result in almost any request from the government giving rise to the Crown use defence. For example, in areas such as pharmaceuticals, where if there was a request to purchase drugs from the NHS, that could have been covered, and it opened up a massive liability potentially for the government, who had to pay the relevant licence fees where the Crown use defence is in play. Although there is a slight spoiler alert for next year's top 10. In mid-February, the Court of Appeal reversed this decision, and there's a leading judgment from Lord Justice Arnold, and he provides some 13 reasons why this decision was wrong. And he said that the express authorization to work a patent or an authorization to do a particular act where to do so has to necessarily infringe a patent was the most appropriate interpretation. So really putting back the status quo there, Lord Justice Arnold, but a very interesting decision from Douglas Campbell at first instance last year.
Thanks, Naomi. So taking a look back at another life sciences case, and at number 4 is Fibrogen and Achivia. So taking a look at the background, this was a complex patent dispute that involved 6 patents in 2 patent families, and the patents related to the use of inhibitors for treating various types of anemia and related conditions. The proceedings were started as invalidity proceedings by Achivia and Otsuka to clear the way for their own product, which was in phase 3 clinical trials, and subsequently Astellas, the exclusive licensee of the patents, brought a claim for threatened infringement. The 2 patent families, known as Family A and Family B, were dealt with separately in the proceedings. The Family A patents had an earlier priority date, and one of the patents in Family A was alleged as prior art for lack of inventive step in relation to all of the Family B patents. However, one common theme was the interpretation of Marcouche formula claims across both the families. As I mentioned, the case dealt with inventive step. It also dealt with matters of insufficiency, infringement by equivalence, and the threatened indirect infringement of medical use claims. So what happened? The judgment of Arnold ran to 640 paragraphs, and I have attempted to provide a summary in 1 slide, which doesn't do the case or the decision justice. But to provide a little bit more information, in essence, there was no finding of obviousness over the cited prior art of the Family A patents, which was a publication called Epstein. While the judge considered it would be obvious to take some of the steps following Epstein, the routine testing which would be undertaken wouldn't lead to the compound in the patent. On sufficiency, the defendants had alleged a breadth of claim of Biogen insufficiency as well as uncertainty or ambiguity in the patent. The judge stepped through the law and drew particular reliance on the case of Idenix and Gilead. The claims fell for insufficiency, for Biogen insufficiency of being implausible, it being held based on the evidence that not a substantial number of the compounds which fell within Formula 1 would be effective. In case he was wrong on this, the judge looked at undue burden, concluding that it may not even be possible in many lifetimes of sustained effort to make and test more than a fraction of the compounds claimed, and a substantial proportion could not be made or would not work. In case more was needed, Arnold also held that the claims would be uncertain or are uncertain. And in light of his findings on insufficiency, he held that the family A patents were also invalid for agreeable obviousness. On infringement of the family A patents, one claim would have been infringed if valid. However, the main arguments were over infringement by equivalence between the claim held valid and Achivia's product. This claim related to a compound C, which had a number of structural differences to the compound in Achivia's product. These structural differences were held to give rise to differences in activity, and so the judge held, when considering the three-stage Octavis test for equivalence, that the product did not achieve the same result in the same way. The claimants also fell at stage 3 of the Octavis test, with the judge holding that strict compliance with the wording of the claim was required, and that based on several reasons, including taking account of the prosecution history where the patent particular claim limitations had been put on the claim. In relation to the family B patents, these were all held obvious over the cited family A patent mentioned before, and the sufficiency issues were very similar to those on the family A patents. So all but 2 claims fell for insufficiency as well. The main interest for the family B patents was the claim for threatened infringement. As I mentioned before, this was for indirect infringement, and it related to an EPC 2000 claim. So it's one of only a few cases looking at this point. Achivia's product was in phase 3 clinical trials, as we said. The SMPC was not yet set, and the evidence before the court was therefore only on how the medicine is likely to be prescribed rather than how it was being prescribed. And based on the evidence before the court, the defendants were held not to be threatening to infringe the patents, as it was not obvious that their product was suitable for or intended to put the claimed inventions into effect. So why was this decision important? Like some of the cases that have gone before it in Idenix and even Shionogi, it looks at the sufficiency of broad claims and what implications that might have for future claim drafting is something for us all to consider. It looks at and tests the scope of the doctrinal equivalence on the structure of compounds that are claimed. It looks at the right time to bring an infringement action. Was it too early here? And if evidence of actual prescribing which showed infringing was around, would a different result have been given? The judgment also gives some guidance to practitioners on instructing experts and on the need for primers. And I think it's fair to say that as a result of this case, in all but the exceptional proceedings, a technical primer should be prepared by the parties where the patent case has a technical rating of 4 or 5. This judgment is on appeal, with a hearing due to be heard in early June. So we may see more from this dispute between the parties in next year's top 20, but certainly later this year at the Court of Appeal.
Thanks, Katie.
Super. So my next cases, I'm going to take on the main duo of the strikeout and summary judgment decisions that have looked at the scope of FRAND damages. There are a couple of other cases along the way which I'll just mention as I go through them. There's been no binding decision on this subject, but in his Unwired Planet decision, Mr. Justice Birse made an obiter finding that where there was no forward-looking licence to include a backwards release clause, damages should be calculated by applying the same portfolio rates to the UK sales only. This is still a very much an open question, and arguments span the whole range of possible calculations, from single patent UK-only damages to a global portfolio-wide basis for calculating them. So the first one to look at is the case of Phillips and Asus Tech. And in this case, this is another one that was heard by Mr. Justice Marcus Smith. And this was a strikeout application in relation to Phillips's argument that damages should be calculated on the basis of the lost revenue under the global FRAND license that the defendants should have taken to the whole portfolio. Following a finding of infringement, Asus submitted to an injunction and argued that damages should simply be calculated by applying the global royalty rate to its infringing UK devices. Phillips argued that the damages should actually be calculated by looking at the appropriate counterfactual license, which it said would have been the global portfolio license that required the payment of royalties on all of the defendant's sales, not just those that had been found to be infringing UK patents. I think it's fair to say the judge wasn't really convinced that either party was right. He said the defendant's measure risked undercompensating Phillips, but Phillips's argument risked overcompensating them, and potentially took the court into the type of jurisdictional encroachment that Lord Justice Floyd had described as jurisdictional imperialism in TQ Delta. He looked at the case of Meters and Metropolitan and found that the guiding principle was to find the measure of damages that would have been paid by the defendant if it had done what it should have done and entered a license that would have rendered its infringing acts lawful. The judge said that any automatic linkage between the forward-looking FRAND license and the relevant counterfactual license was wrong, but he also noted that completely disregarding the FRAND terms when determining damages in this type of case was equally wrong. The judge refused the strikeout application, noting that this issue was in no way susceptible to summary determination. Now, before we tackle the next strikeout decision, I'll just mention briefly, without any spoilers, the Supreme Court Unwired Planet decision. You'll be unsurprised to hear that might be coming up later. This highlighted that the damages assessment is of a different nature to the FRAND determination and warned against equating the two, but they did also note that damages, when calculated, the damages payable might be the same as the royalties payable under the FRAND license. There was also a decision from Mr. Justice Mann in the context of a disclosure application in Phillips's case against TCL. And in that case, he followed Mr. Justice Marcus Smith's decision and allowed the disclosure of global sales figures. He said not doing so would have been akin to the strikeout, to a strikeout or summary judgment. So our next substantive strikeout application was that of Mr. Justice Birse in IPCOM HTC. Again, HTC's application asked for damages to be limited to royalties payable only on infringing devices sold in the UK, and that was those phones that didn't use one of the court-approved workarounds. And they said for non-UK devices, there had been no infringement of a UK patent, so the damages claimed in relation to those devices should be struck out. In the same way as Phillips had, IPCOM argued that the damages should be calculated by reference to the counterfactual license, this one again being global in scope, covering the whole portfolio and charging a royalty on every 2G, 3G or 4G device sold anywhere in the world. Taking the exact opposite approach to Mr. Justice Marcus Smith and Mr. Justice Mann, Mr. Justice Birse rejected IPCOM's argument completely at this stage and struck out the part of IPCOM's claim relating to overseas sales. He held that those sales were not caused by any active infringement in the UK of any active infringement of a UK patent and weren't convoy goods of the type discussed in Gerber and Lectra. He also said that this part of the damages claim failed the remoteness test. He said that when you're looking at a global FRAND license, that was based on the ETSI undertaking and not national patent law. He didn't strike out the portion of IPCOM's claim relating to non-infringing UK sales, but he did note that if he wasn't bound by authority, he would have said that the portfolio approach to damages in his UP decision was only appropriate by way of concession. So we felt that was important because we can see the judges taking completely opposite approaches to each other. What one thought was impossible to determine on a summary basis, the other was happy to merrily strike it out in, I would say, strong terms in the judgment. This is going up to the Court of Appeal in October this year, so another one, it's a bit of a theme for this year's top 10, another one to watch this space.
Thanks, Naomi. I think we reached the top two, and I think it's going to be no surprise probably what these two are. So in at number 2, we have Regeneron and Kymab from the Supreme Court. So these proceedings have been going on for a while. So to give you a bit of brief background, the proceedings were brought by Regeneron in 2013, which is shown on the next slide. And they allege infringement of Regeneron's patents relating to transgenic mice by Kymab's product, a transgenic mouse called Kymab. Kymab counterclaimed that the patents were invalid due to lack of novelty, inventive step, and insufficiency of disclosure. Claim 1 of a product patent was a claim on which all the other claims stood or fell, and an important feature of construction at both first instance and on appeal was that claim 1 was found to extend to a range of mice. So what happened? At first instance, Mr. Justice Henry Carr found the patents novel, inventive, and infringed, but they were invalid for lack of sufficiency. He held that the methods disclosed in the patent would not be workable by the skilled person at the priority date without an undue burden or invention, as the insertion or deletion of large pieces of DNA, which was part of the patent, was not possible at the time. On appeal, that decision was reversed, and Regeneron presented some new arguments that the skilled person would have used his or her common general knowledge to make adjustments to the methods in the patent so as to insert smaller inserts of DNA into the mouse genome in a stepwise manner. Regeneron accepted that these smaller pieces would only allow the skilled person to make a small range of the mice claimed in the patent, but they argued that was enough. The Court of Appeal was persuaded by the argument. Crucially, it considered that the invention amounted to a principle of general application, which might contribute to the art not only for the current products, but also for products which might become capable of being used in the future. It was held that every transgenic mouse using the reverse chimeric locus of the patent, and not just those with human variable regions, would benefit from the invention, because the invention essentially cured murine immunological sickness. So the Court of Appeal, as I said, found that this teaching was properly taught, or the teaching of the reverse chimeric locus of the patent was properly taught, and that amounted to this generally applicable principle, and the sufficiency requirement was therefore met. At the Supreme Court, on the next slide, they considered the question of law of sufficiency, and the Supreme Court considered that the Court of Appeal's reasoning was sophisticated and logical and helpful to increase the rewards in a complicated and fast-moving field like those in issue. However, they essentially disagreed with the outcome, noting that the contribution of Regeneron's patents was smaller than that was claimed, and this meant the essential patent bargain, the trade-off between disclosure and time-limited monopoly, had not been achieved. Lord Briggs gave the leading judgment, and he takes a look through the UK and EPO case law on insufficiency and generated 8 guiding principles. Among those, he confirmed that for a product claim, what must be disclosed is the product and the ability to make that product, rather than the invention or inventive concept, if that is something that's different. In the context of a patent claiming a range of products, the patentee is required to disclose enough information that, coupled with the CGK, it would be sufficient to enable the skilled person to make substantially all of the embodiments of the product within the scope of the claims range. This was obviously kind of carving out from that was kind of de minimis arguments, and that wasn't something that was an issue in the Regeneron case. Lord Briggs also confirmed that the patentee may rely on a principle of general application, if it would appear reasonably likely to enable the whole range of the products within the scope of the claim to be made, although the patentee would always run the risk that this could be challenged later. Finally, Lord Briggs had said that the requirement of sufficiency only related to relevant ranges, and an example of a range that wasn't relevant in this case was something like the length of the mouse's tail. It's interesting to note that Lady Black gave a dissenting judgment and agreed with the Court of Appeal that the invention or the patent was amounted to a principle of general application and was therefore sufficient. So why is this case important? So the principles laid down may be a summary of the current EU and EPO and UK case law, but they'll likely be reproduced in case after case, and their relevancy to other types of patent will be of interest. We've already seen this happening in action in the recent High Court decision in Illumina. Burse applied the Regeneron principles to a process patent case and looked at how those principles needed to be amended to be applied in that circumstance and made more general. Looking at the Regeneron case itself and what this means for patentees, we may see more amendments to narrow claims to maintain sufficiency. Obviously, that might bring about trade-offs in relation to infringement and squeezes there. But we may also see during patent prosecution later filing to de-risk this kind of principle of general application, or potentially maybe more divisionals being filed to protect positions. Time will tell.
Watch this space again. So our top case is the long-awaited Supreme Court decision in the Unwired Planet and Conversant cases. And this all stems from Mr. Justice Burst's decision, as he then was, back in 2017, which set the terms for a global portfolio-wide FRAND license and established that if a defendant didn't undertake to enter that license, they could be injuncted. Unsurprisingly, that triggered a wave of FRAND litigation in the UK, with SEP holders keen to get their global license term set and keen to take advantage of the powerful new FRAND injunction. One of those cases was commenced by Conversant, and in that action, Mr. Justice Henry Carr held that the UK court had jurisdiction to conduct a FRAND determination, even in circumstances where the overwhelming majority of the defendants' businesses weren't in their jurisdiction. The Court of Appeal essentially approved those two decisions, save for Mr. Justice Burst's one true FRAND point, and the appeals were conjoined and sent up to the Supreme Court and were heard in October 2019. This hotly anticipated decision was handed down in August last year, and it deals with 5 key questions, which I'll take in turn, bearing in mind I'm doing them at a breakneck speed to try and not to go over the time too much. So the first question was whether the UK court could set the terms of a global FRAND license and then grant an injunction if the defendants refused to enter that license. Despite Huawei's comity arguments, the court said that setting such a license didn't involve any adjudication on the validity and infringement of foreign patents. That, it said, lay exclusively within the jurisdiction of the court of the state that granted the right, and it was just the ETSI IPR policy, in fact, that enabled the court to set the license terms. That policy and its international effect was intended to mirror the industry practice of setting global licenses to the portfolios, and the policy also envisaged that a court could determine the scope of the contractual obligation created when an SEP holder gave the required irrevocable undertaking to license its patents on FRAND terms. There was no prohibition in the IPR policy against an SEP holder seeking an injunction. However, the policy does impose a limitation on that ability by way of the undertaking. If the implementer accepts the license, there could be no injunction. Whilst the court acknowledged that Mr. Justice Burst had gone further than any other court in his willingness to set FRAND terms, when they reviewed the cases from various jurisdictions, they concluded that the English court's approach wasn't out of line with any of those other courts. Next, the court turned to the issue raised in the jurisdiction challenge in the Conversant case, and that essentially boiled down to the question of whether China, rather than England, was the appropriate forum for the FRAND dispute. Huawei and ZTE said that the real dispute between the parties was just a dispute to the applicable FRAND terms, and the claimant, they said, was just using the English injunction to provide a hook for that dispute. The court had to decide whether its jurisdiction of that or that of the suggested foreign court was a more suitable forum for the determination of the dispute between the parties. The traditional way in which that question has been framed speaks of the forum in which the case can be suitably tried in the interest of all the parties and for the ends of justice. So what, the court said, was the case to be tried? Was it purely about the global FRAND license, or was it about the validity and infringement of English patent rights, with FRAND arising as a pleaded contractual defence? The court said that if it had been necessary to choose between those two options, it would have preferred the claimant's characterisation. The owner of a portfolio of patents is allowed to choose which of its rights it wants to assert and can't be forced to enforce patents in other countries because of a common FRAND offence. However, the court said that this argument failed at an earlier stage. In a foreign convenience argument, the challenger had to identify a different forum that did have the jurisdiction to determine the dispute. China was the only candidate in this case, and the judge had heard evidence that the Chinese court at that stage didn't have the jurisdiction to determine global FRAND terms in the absence of the agreement of all the parties. Despite some new evidence on the evolving practices of the Chinese court in this type of case, the court agreed that there was still only a speculative possibility that the Chinese court might accept jurisdiction, so that jurisdiction challenge should have been rightly rejected. Huawei's next issue was that it argued that under Unwired Planet's non-discrimination obligation, it had to offer it the same license terms as those that it offered to Samsung when it settled out of the case at an earlier stage. Huawei said that the non-discrimination obligation required Unwired Planet to offer it a global royalty rate that was at least as favourable as that, because it was a similarly situated licensee. In rejecting this argument, the court found that the undertaking created a single unitary obligation with the non-discrimination aspects helping to give colour to what should be said to be fair and reasonable. Having looked at the obligation in this way, the Supreme Court said that it indicated that there was a single fair market price that should be generally available to all market participants, and that had to reflect the true value of the SEPs and didn't need adjusting depending on the characteristics of any given licensee. There was, they said, no hard-edged non-discrimination obligation. Despite the fact that there was one FRAND price, the SEP holders still had the ability to license its portfolio at a rate below that FRAND price, often the case to give somebody a first mover advantage or as part of a file sale to generate much needed funds. If those licenses were taken to dictate the FRAND rate, a portfolio holder couldn't do that without permanently devaluing its rights. And it would also remove the incentive for an implementer to take advantage of those reduced rates. Next thing the court turned to was the FRAND dance set down by the CJEU in the case of Huawei and ZTE. Huawei argued that the steps laid out were a set of mandatory conditions that the SEP holder had to comply with in order to be able to attain an injunction, and that as UP hadn't made a FRAND offer at any stage, its remedies should be limited to damages alone. The court upheld the decision of Mr. Justice Burse and the Court of Appeal in this case and said they'd been right to reject this argument. Bringing an action without any prior notice or without any prior consultation with the implementer would be an abuse of a dominant position and a breach of Article 102. But whilst this consultation was mandatory, its nature would depend on the circumstances of each case, and there was a significant degree of flexibility given the wide range of possible factual scenarios. This mandatory requirement prevents an organisation who's unknowingly using an SEP from being ambushed by an injunction. The court agreed with Unwired Planet that the CJEU had set out the signpost to a safe harbour for the SEP holder, who's told that if it follows all of those steps, it would definitely not be abusing its dominant position. They said that wasn't the same as saying that not following any of those steps, apart from the consultation one, would mean that it would definitely be abusing its dominant position. So some flexibility for SEP holders there. And finally, the court turned to a question that it hadn't been raised in front of any of the lower courts, and that was whether, even if an SEP holder is willing to grant a licence on terms deemed to be FRAND by the court should still refuse to grant an injunction because it wouldn't be appropriate or proportionate. The argument went that as the claimants were only interested in royalties, that could be fully dealt with by way of damages in lieu of an injunction. This was rejected by the court. They said that the limitation placed on non-practicing entities' ability to seek injunctive relief in the United States following the case of eBay was born out of a concern that their injunction were being used as a bargaining tool for exorbitant license fees. That, they said, wasn't a concern here because as the patentee can't enforce its right for an injunction unless they've offered a license on FRAND terms, no higher rate could be secured. Damages, they said, were unlikely to be an adequate substitute for an injunction owing to the global nature of standardized technology, and that when you confined an SEP holder to a monetary remedy, it would remove the economic incentives for the infringing implementer to take the global FRAND license, and instead would encourage implementers to hold out and would force patentees to seek royalties on a patent-by-patent, country-by-country basis. Right, so that whistle-stop tour through the Supreme Court decision. And we can see that that's important because it provides clarity on the key FRAND issues that we've been grappling with for years. And maybe importantly, signals that the UK court is open for business as a forum for FRAND disputes and is willing and able to set the terms of a global portfolio-wide license and allow an injunction to be used as a tool to get implementers to take that license.
Lovely. Thank you very, very much, Naomi and Katie, for a very comprehensive run through of those cases. It's tipped us slightly over time, so I'm conscious not to keep people on the line very much longer. We haven't received any questions as we've gone along, so I don't propose to ask any, only just to say that this video will be has been recorded and will be made available later on for people who didn't catch all of it, and we are looking forward to releasing our printed patent case review, which will be circulated by email next week. So thank you everybody very much for dialing in. It's been a pleasure to have you with us, and please enjoy the rest of your day. Thank you.
Thank you.